All right, I'm going to go ahead and call Juvenile Justice to order. First, I know Senator Strickland is in 307 chairing Senate Judiciary, so I'm going to call upon Senator Brass to present SB 216 to the committee. He was just outside. No, he was right outside. I saw him when I walked in. No worries. You can present at the podium or at the table, either or. The table's fine. You might as well sit down and be comfy. It's been a long day.
It has been, Madam Chair. What bill would you like to start on?
216, please.
216. So 216 is very simple. As most of y'all are probably well aware what respite care is. You know, and for those of you that are not, it's just simply temporary relief for foster parents. Allows a family to come in or a person to come in and give some sort of temporary assistance to maybe in the form of babysitting. And so current state law is there's a 72-hour cap on that. And so all we're simply doing is giving the department the discretion to extend it out past that 72 hours. Mm-hmm. It would be on a case-by-case basis, but you know, this might be maybe you got a foster couple that wants to go on vacation without children. As a parent of 3 children, I can relate to that. So this would allow them, maybe they want to go out of town for, you know, a week, and this would allow respite care to extend past that.
Mm-hmm.
It's very simple.
Appreciate that. Tell me, and it's been several bills ago that I read through this. Would it allow, I know one of the things that foster children are often prohibited from is spending the night with friends. Is that allowed or prohibited in this bill?
I think I would guess what would happen there was if maybe the parent that they're spending the night with would have to be, if they were respite parents or respite care, mm-hmm. Then it would apply to them. Okay. If they were not, then mm-hmm. it would not, and they'd fall under a total whatever the current law is. Yeah. I guidelines.
Just kind of fingers crossed that would get fixed at some point in time, but it sounds like a good bill for next year. So
could be. I would support something like that.
So members of the committee, do you have any questions for the good senator on Senate Bill 216? Again, we are working from SB 216/FA. Wow. Several questions. And I'm going to be rude and refer to you by your microphone number. That's just easier. Number 1.
I like that, number 1. Better than Hutchison.
That's a good number.
So one thing I wanted, thank you for the bill, by the way.
Sure.
One thing that I know foster parents use respite for is if they want to go on vacation, it's out of state, and it takes so long for the state to approve the children leaving the state that it's just easier to use respite care. Mm-hmm. But my question is, so are you substituting babysitting with respite? Is that in the language?
I think it's just updating the language. Okay. You know, we used to use foster care, babysit. You know, I think it's just updating the language.
So, is there a different requirement for a babysitter versus a respite care provider?
The department can probably speak specifically on that, but I don't believe there is. Is that good or bad?
It's
good.
Just updating terminology, and then it sets the parameters for anyone that would take care of the foster child for a specified time period.
Thanks.
Okay. Thank you, number 1. Number 15.
Thank you, Madam Chair. I think this is a good bill, and at the proper time, I would like to make a motion to pass.
Okay. All right. Just suspend for a moment, and we'll see. Are there any other questions on Senate Bill 216? Okay. At this time, the chair will hear from number 50.
I would like a motion, make a motion to pass.
Okay, we have a motion to pass on Senate Bill 216, SB 216/FA. There was a motion, there was several seconds. Any discussion? Hearing none, all those in favor, please signify by saying aye. All those opposed, like sign. Motion passes.
Thank you.
You're well on your way to House floor. Who is going to be carrying this bill for you?
We'll get to skip rules. You know what? I don't know. Did we? Does anybody?
Okay, I'll carry it.
I'd be honored to have you
Yes.
carry it, Madam Chair. Thank
That's
you.
fine. I know there was some discussion early on. I didn't know if there had been any changes, but I'm happy
Okay.
to carry it for you.
Perfect. Thank you.
All right,
All
and
these bills, I'm getting confused on who's doing what. So.
I'm there with you. So we're going a little bit out of order. We're going to go ahead and hear Senate Bill 230. This is the chair is going to use some chair discretion and move this to a hearing only. Some folks have approached her about some potential language changes. No worries, Mr. Chairman. We do have another committee meeting for tomorrow.
Okay.
So, and I do apologize. It was just one of those days. So this will be a hearing only on Senate Bill 230. We are working from LC 339329. Mr.
Okay.
Chairman?
Sure. So, if many of y'all remember, we passed a foster parent bill of rights, almost 20 years ago. And so really the intent of this bill is to update and also strengthen that law. And so we're expanding it to other caregivers of children in DFACS custody, and clarifies that foster parents can seek advice and assistance from attorneys and certified volunteer advocates if they have concerns about fostering or really if about a child in care. So kind of in sections, the beginning sections, you'll see certified volunteer advocate as an individual has been vetted and approved to be such by the Office of the Child Advocate. We're defining a foster parent to include foster parents, fictive kin, and relative caregivers who are providing care to a child in custody of DFACS. We're also adding to the Bill of Rights the ability of caregivers to use the reasonable and prudent parenting standard. That's current law that's throughout code, and so we're allowing that to apply to these caregivers as well. We're also going to require DFACS to develop a better procedure for addressing situations where a foster parent may have had a violation of policy. So it's really, this is just a due process in making sure that there is a clear due process for these foster parents. And we're also creating more flexibility in who can assist foster parents should they have a grievance with DFACS. If they need assistance in meetings regarding the child or accused of violating policy. So you'll see that under the certified volunteer advocate can be a support person for the foster parent caregiver in those meetings and is bound by confidentiality. We're also clarifying that a foster parent can seek and obtain independent legal advice at their own expense. And we're also prohibiting discrimination or retaliation against foster parents should they file a complaint against DFACS. And we're expanding the ability of foster parent advocacy organizations to assist DFACS in creating and reviewing the policies created pursuant to this law. So again, the intent is to just strengthen our foster parent bill of rights. I think we all know and agree that, when the state takes custody of these children, it becomes our responsibility. We need help. We need to support our foster parents the best we can, because they're really stepping up where there's a lack of care. And so anything we can do to help them, and really just help them understand the processes a little bit better, and also, making sure that due process is in place. Should you have, someone at the department that's, if they have an issue, that's fine, but there needs to be a clear process as to, what that issue is and how we can how they can remedy it. So
Mm-hmm.
that's the purpose of the bill.
Okay. All right. Members of the committee, do you have any questions? Number 12. I think that's Mary Margaret.
Thank you very much. I'm trying to remember, and I can't remember. Did we ever decide a foster care parent is a party to a juvenile court action, or they are still not a party to a juvenile court action? This does or does not change this? Does not change that.
My understanding, if I remember correctly, I don't think we ever did change that. Any help back there? I
I'm
don't
getting
think
nods
we
that
ever
we did not.
changed that, and
This
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 does
takes some
not.
steps a little bit to it.
a little bit to it, but gives them some legal representation. When right now they don't. I mean, they can't.
Well, if they're not a party, what good does a lawyer do? I mean, that's what, they hire a lawyer to talk out to the lawyer in the hall. That's what confused me. When you say they have a right to lawyer, that's only in their licensure disciplinary process. Is that what you're talking about? Not in the child's courtroom, but in the foster care status. I'm seeing some nods. That I just said that correctly. Do you think I said it right or wrong?
That sounds right to me. Yes.
Madam Chair, the issue that you're concerned about what can a foster care parent allow a child to do is something I've paid attention to. So if we look over here on 50, line 50, page 3,
Mm-hmm.
it looks like that kind of goes towards the purpose of spend the night with your friend should be something that the foster care parent could decide. And that's what I'm asking you, Senator, if you agree with me, or why do you need 3.1 on line 50?
I don't think I have y'all. What LC are you operating on?
LC 339329.
Okay, and you said line 50.
Page 3, line 50, paragraph 3.1. Why do you need that language?
That's current law.
It's underlined, so tell me,
Line 50 is not underlined on mine.
then we need to,
Make sure I'm looking at it.
it's underlined.
Do we
May I
have the,
approach the bench?
do we have the correct LC number?
Here's the number. Maybe I have the wrong one.
Yeah.
Yours different. And what's your? Are we 9329? Is that what we're looking at?
That's what I was provided.
I don't know what I got.
A special author copy.
Who am I?
Page 3, line 50.
Would you like to go forth with a different LC number?
No,
Okay.
I don't. I may be looking at.
Am
I
looking
I
at the
really
wrong
don't know
bill?
how these are different because it would be a different LC number. I don't. I'm confused, but whatever.
It is the one that passed the Senate.
No, I know. I may just have the original. My
Understand.
original language.
Well, let me just ask you this way.
But-
Why do we need language? What causes, this is a department bill?
This one was not a department bill.
Where
no.
did it come
This
from?
came from a group of advocates,
Okay.
foster parent advocates.
So these advocates don't think they have the right now to use a reasonable, prudent parent standard when determining ability of a child to engage in extracurricular enrichment, cultural, social, or skill-building activity.
Madam Chair, would you allow me to bring up Tom Rawlings to help me
I
with my
will
bill?
recognize Mr. Rawlings. Mr. Rawlings?
Thank you.
There we go.
Representative Oliver, yes, currently there is a federal requirement and a state requirement that foster parents be allowed to use the reasonable and prudent parenting standard. That was not the law at the time the original bill was passed in 2004, was it? So I thought it would make sense to put it in there just as one of the other rights that foster parents have. As you are aware, this Bill of Rights does not give court enforceable rights to foster parents and other caregivers.
Because they're not a party.
Sorry?
Because they're not a party.
Because they're not a party to the action.
Because they are not a party, and they are not a party under this either. I will say that the issue about attorneys is that currently if a foster parent has a substantiation the current process is that they can appeal that substantiation. Of course, you realize we got rid of the child abuse registry a few years ago, but there's still a sort of a list of people who've been substantiated against. If you were to be a foster parent who had a substantiation against you, and you were to try to appeal that, then you have a local person review the file, you have a second person review the file, and then you have the commissioner review the file, and your attorney can be present but can't say a word. And so I think the key here is not getting attorneys involved in the juvenile court process itself. It is really completely applies to the grievance process when a foster parent has been substantiated against.
Madam Chair, it sounds to me like, I'm good with that. That makes sense to me.
Mm-hmm.
Back to the language on line 50 that you tell me is already federal law, so it's already applies, but we're just putting it in here. Really, the purpose of it is to clarify for the state. It really doesn't need clarification that foster care parents do have the right to decide if a child gets to go to a spend the night party or gets to go to Stone Mountain Park this weekend. Isn't that what this says?
Yes, ma'am. They do have that right to send the child overnight to a party, to send the child to prom, to have the child go with a student body to some sort of to Atlanta to see the legislature and spend the night.
And to go to Jekyll Island for 4-H camp,
Mm-hmm.
but not go to Florida. They cannot go to Florida. Can they go to Florida on vacation with the foster care parent?
Can't go to Florida without permission from the commissioner to leave the state.
Okay, I got it now. Thank you.
Okay.
So we don't need a bill for that?
I think what they're saying is just for clarification, edification. So,
Doesn't change
Okay.
the law. It just says we're going to file a federal law. That's what it says to me.
yes.
Okay.
Okay. Does anybody else have any questions regarding what we have decided that we're looking at, Senate Bill 230, LC 339329? Does anybody else have any questions on that matter? Okay. It is for hearing only, but we do have a committee hearing tomorrow, so we will keep you posted.
Thank you, ma'am.
Thank you, Ms. Chairman. I appreciate your time and attention. At this point, I am going to beg everyone's indulgence, and I'm going to present Senate Bill 133 as it was, as the final sub that has been worked on by both the juvenile judges and the Division of Family and Children Services. So I am going to be presenting Senate Bill 133. We're working from LC 480953S. And you should have a copy of 151112 in your folders for your personal edification if you need to refer back to that. I know that's kind of stressed within this bill that we'll be discussing, that adherence to that statute. So line 16 through 59, and I'm not going to reiterate this every time. I'm just going to basically say it applies to Chin's cases. And then I'm going to say it applies to delinquency cases. So beginning on line 18, prior to placing a child in the custody of DFACS on a non-emergency basis or in the absence of exceptional circumstances, based on the evidence adduced at a disposition hearing, the court shall, and the court means the judge, comply with Article 3 of Chapter 11. Consider on the record what services have been provided to the child or his or her parent or guardian. Consider on the record what services are available to the child or his or her parent or guardian, which could allow the child to remain in the home. Consider on the record what efforts have been made to secure the placement of the child other than in the custody of DFACS. And lastly, consider on the record whether a Child Protective Services report was made in accordance with paragraph 3 of this subsection. And if not, the court shall notify DFACS through the county director, the court liaison, or the attorney representing DFACS by phone or email that the court will be considering placing the child into the custody of DFACS. DFACS shall have an opportunity to be present at the case disposition hearing if they have been, obviously, and I'm going to deviate a little bit, obviously if they have been notified. DFACS will have an opportunity to be present at the case disposition hearing of the child in need of services to provide information to the court as to the availability of services for the child. In any CHINS case in which DJJ or any county-operated probation office serving the court determines there is a reasonable basis to believe that the child is dependent, it shall make a Child Protective Services report to the statewide Child Protective Services Communication Center and shall notify the county director of the DFACS office in the county in which the disposition was made. Once a child has been ordered into DFACS custody, the court shall comply with Article 3 of Chapter 11. See, there's a theme. Shall comply with Article 3 of Chapter 11, including conducting a preliminary protective hearing no later than 72 hours after the child has been placed in DFACS custody as required by Code Section 1511-145. That is already in statute. That's just kind of a restatement that they have to have that hearing within 72 hours. All parties to the CHINS cases shall provide copies of all medical, psychological, and educational assessments and reports pertaining to the child and the child's parent or guardian in their possession to DFACS no later than 72 hours after a child has been ordered into the custody of DFACS by the court. And then lastly, the court shall make an inquiry as to whether any parties to the CHINS case or court personnel, including the court clerk's file, have either possession of or immediate access to such records. The parties or personnel in possession of such records or with access to such records shall provide copies of all such records to DFACS. Each county DFACS office shall designate at least one county DFACS employee to receive such documents via email. The court shall also inquire of all parties to the CHINS case as to the existence of assessments, evaluations, and reports pertaining to the child that are not in the possession of all parties. If any such records exist, the court shall immediately order the production of said records to DFACS. Nothing contained in this code section shall abrogate the authority of the court to order a child into protective custody in accordance with 1511-133. And basically, under Section 4, we're basically saying the same thing, but in a delinquency case. So that is it, ladies and gentlemen. I know there's been a lot of wailing and gnashing of teeth and, a lot of things kind of going on with regards to this bill. But it's just basically saying you have to apply the deprivation standard once a child is ordered into care. There was an instance where a child was ordered into care. The deprivation proceedings did not kick over. And the child languished in care for well over a year because there simply wasn't a hearing. The child wasn't in the system. It didn't come back as needing a hearing. So unfortunately, it just kind of languished in care for quite some time. This is what this bill is designed to prevent. We're not plowing any new ground here. It's just we're asking the judges to comply. We're asking them to consider different things, and we're asking for basically to DFACS to have its itself heard and also get the reports that it needs to provide adequate care to this child. And I will specify and state that this is about the children. This is about the kids that DFACS has the custody of. This is not about whether or not one adult or another adult is happy or sad. It's just how we want our children treated and the services that we want provided to them by ourselves, by the state. This is an executive branch. So we are here to basically settle the policy, which is what the legislature is in charge of. The policy of how we want our children treated is what this boils down to in delinquency cases and in Chin's cases, while not making DFACS a party to those actions, but also knowing that these things are happening. And, you know, ladies and gentlemen, I will tell you, as somebody who goes to a lot of these child abuse prevention, conferences and things like that, you know, we talk a lot about ACEs, which are adverse childhood experiences, and how detrimental those are to the child. And every time we move that child, we click up on those ACEs. And that's a very unfortunate circumstance and one to be avoided. We should not do that lightly. We shouldn't do that. We should take all care into consideration, not only to make sure that the child's needs are being met, that the child's needs can be met, but that they will be met in a timely fashion. So with that, I did see the sponsor of the bill come in. I will recognize Senator Strickland. If y'all have any questions, Senator Strickland, obviously he's much more familiar with this area specifically than I am. So I will ask him to answer any questions. So you have, are there any kind of opening statements you'd like to make,
The only thing
Senator?
I'll say, Madam Chair, I apologize for being late. I'm chairing our Judiciary Committee. We have 10 House bills we're moving right now. Right now, Senator Calvert's in charge without me being there, so I'll give you fair warning. Some people got that joke. No, I think you wrapped up very well. I'll just say from a process standpoint, we have really, this is one of those bills that truly the process has worked. We revised the bill in committee in the Senate. We took it to the floor and got, I think it was 53-1 vote passing it. But despite that, we still said we want to continue to have people at the table making sure we're getting this right. I was on about a 2-hour call or so on Friday, still making more changes to the bill, the substitute that you have. You've stated it perfectly. We're not plowing new ground. We're trying to make sure, though, that we have some really basic due process rights built in. And again, no one here speaks for parents a lot of times because we focus a lot on the children as we should, but parents also have rights in these proceedings where their kids are being taken away. And so this comes from the department, from DFACS, because a lot of the issue is making sure that they are at the table and they at least have the information they need to properly place the child. But with having the Article 3 protections, as you mentioned, with dependency actions come into place, then we know that everybody has counsel. The process will work. We have automatic hearings set up to make sure that everyone's well represented throughout this process. And we use extreme examples sometimes, and I'll tell you, the judges I've worked with are not doing anything wrong. These aren't, the people you may see speak and have spoken previously in the committee aren't bad actors. We just have inconsistencies, and so it's done differently in different courtrooms on our state. We want to make sure that in every corner of our state we have a standardized process. So I ask for your support of the bill, and happy to jump into more weeds of this if I need to, Madam Chair. I know y'all have heard it a couple times now, so.
Okay, all right, several questions. Number 25.
Thank you, Madam Chair. I have a question, and it may be something that was changed because I can't really see it in here. But I had a question asked of me. If a child comes in currently, our judges have the ability to make an immediate action. And so the question was, can they still make an immediate action when it's necessary and there's not a delay on what they can do?
And that's right. And that is, if you look at lines, are y'all working on 480953S? Okay.
Yes.
Lines 58 and 59, and also in the next section, that's going to be lines 107 and 108. That is the emergency authority of a court. And so the other concern, so first question, this doesn't prevent a judge from doing anything on an emergency basis. We codified that to make sure that code section was still in place. We also removed part of the bill that we had last time I was here that allowed DFACS to seek a continuance, because there was some concern raised from the judges that the way it was worded, where they have to wait for DFACS to get there, could that affect a child emergency situation? That was also taken out. And so nothing in this is meant to change what will happen on an emergency basis. What changes is what happens after the emergency has been addressed, what process then comes into play. Thank you.
Okay, thank you. Number 27.
Thank you, Madam Chair, and thank you, Mr. Chairman, for your presentation. So I'm looking at line 28 of the bill, and it indicates that the court should consider on the record whether a Child Protective Services report was made. And how is the court to know if a report was made?
So my understanding, and somebody correct me if I'm wrong, is they can make an inquiry as to whether it was done with the parties that are in the room. And if a report was not made, that kicks in that process. That's getting, again, notice to DFACS as to what's happening with the child. Am I correct on that? So the judge you're in a Chin's case, for example, in the section you pointed to, a judge would inquire as to whether a report has been made by the people in the room. And if it can't be shown a report's been made, then this provision would kick in.
Okay, so that's, of course, assuming the department's present, and there'd be the opportunity to ask that.
That's right.
And if a report was made, then the court would be required by law to consider it.
That's right.
All right, and then follow-up question is on line 32, indicate that DFAC should have an opportunity to be present at the case disposition hearing. You were talking earlier about an emergency hearing requirement to be present isn't in place in this bill, but looks like for the disposition hearing, as I understand this language, the department would just have an opportunity to be present, but there's no requirement that
That's
they be
right.
present as well. Is
And
that
you'll
correct?
see, if you had all the other versions of the bill, you see how much that's evolved from the court shall consider, shall make findings, to DFACS shall be entitled to continuance. Now we're down to shall have the opportunity. But obviously, again, we go back on the provisions that Representative Lott asked me about. Emergency basis, the law stays as it is. The judge will still make emergency decisions. In addition to that, this does not prevent a court from saying, they could have been here, they're not. We can't get anybody to get here, and still make decisions at that point despite that.
Thank you.
All right, thank you. Representative Oliver.
Thank you for your time and all the folks that worked last Friday on this time trying to resolve these issues. We started with the numbers last week, trying to figure out the real numbers on this. You had 5,324 removals last year. That's what you reported to the feds. And these cases of children coming from DJJ or CHINs that relate to a juvenile court judge taking custody, I just want to see if I've got these, are about 28 children. Is that correct?
I don't know if that number is correct. I think the problem is you don't really have exact data on the numbers. That's not something I think we can necessarily have. We can give you examples, but I can't testify as exact numbers.
And the confusion, I'm getting to a question, Madam Chair. My confusion is trying to understand the diversity of the way the CHINS programs are working across the state. I'm going to make a suggestion, not for this week, but maybe you would consider over the summer having a couple of hearings on, let's look at how CHINS is working. But if you take the emergency situation out, what I'm trying to figure out is when and where the department would not already be involved in some capacity for the child that's being moved from DJJ, from CHINS into DFACS, because the department has an argument to make, a good argument to make, that they don't know what to do if they haven't been involved. But why wouldn't they be involved in these CHINS and DJJ?
Yeah, and it's because of what we're trying to fix with the bill and the CHINs and in the delinquency cases, the DJJ. We have this code section that Regina always gives me every time I present. I think I have 10 copies of it, but that's a good thing. It's OCGA 15-11-12, and that gives.
That's the initiation of the 72. That's the initiation of the petition
No,
section.
that's the dual designation statute.
Okay.
So that's the statute where the power comes in a CHINS case or in a delinquency case to also at a final hearing, the final disposition hearing, either one of those matters, to find a child dependent.
But a disposition hearing is after you've had a bunch of evidence come forward. That's where I'm.
That's right. So that'd be evidence in a CHINS matter where DFACS is not involved, or delinquency matter where DFACS is not involved. And so you get to the end of that, and the law provides authority. And also under the CHINS statute, there's two of the sections that allows a judge to find a child dependent in a CHINS action. And so you have this reference where a child can be found dependent, but then what happens next is what we don't know. And that's the purpose of the bill, because some courts will then treat this like, dependency and start that clock. And you have a 72-hour hearing. Parents have a right to counsel. A child's representative, DFACS gets notified.
And that's what you want.
That's what we're trying to accomplish. And so we're trying to fill that hole. The challenge comes into, and the reason some of the courts have pushed back is I think there's a desire to have more flexibility sometimes in those actions. We've tried to do that here. The balance is, how can we give flexibility in a very difficult situation for a court in a juvenile proceeding to always look out for a child, right? At the same time, there has to be some law, there has to be some due process built in. And again, if you saw the versions of this bill from shall, fine, to now we're just considering, that's intentional, because we have heard the concerns raised by some of the judges that they don't want their hands tied. We don't want their hands tied, but we also have to have a process put in place. I agree with what you said. Do not do juvenile law. I've done a couple just to be dangerous. No, just not to be dangerous in this. But what I've learned myself in working on this is we probably do need to look back at the Chin's law in particular. And I've had the pleasure of being on calls, watching our commissioner speak with some of our leading judges around the state about the challenges both of them see. They aren't always talking to each other about all this all the time. It's been great to watch them come together, and I've watched them share ideas with each other and make notes while they're talking. And so a bigger conversation could be useful in the off season, but I think at a minimum we have to get this hole in the law filled for now.
And Madam Chair, am I correct that we're going to hear from the judges today?
If they've signed up to speak, if they wish to speak, I'm guessing yes.
Thank you.
Thank you.
A number of people have signed up to speak. So, number one.
Thank you again for that.
I just wanted to call you number one, even though I knew who it was by now.
I want a new name tag. Thank you for the bill. I have a question. Is there anywhere where CHINS is defined other than meaning child in need of services? Because I was chair of CHINS in 2 committees, and I was not aware of all the diversity in how CHINS programs is run. So right now, even as a former chair of CHINS, I couldn't tell you what it is.
Well, to be fair, and I was carrying it around today, I left it in my committee room, but the juvenile code does have a whole section on CHINS, and so it's all laid out there. What you're seeing in 1511 442.1 is us adding into that code section this procedure. And so to be fair, there is a whole process set up in code for CHINS cases.
You wouldn't happen to know what the code is.
I'm sure somebody does. Okay, 15-11-2 has the definition, and I think it goes from there in 15-11.
Okay, yeah.
I'm sorry.
Thank you.
Okay, thank you. All right. Members of the committee, do y'all have any more questions of the senator? Okay, seeing none, we're going to move on to our speakers.
Thank you.
We have a number of folks that have signed up, and I would just ask that you be brief. And the first one that has signed up is Judge Sims from the Gwinnett County Juvenile Court. You can either speak from the table or the podium. Okay. All right, y'all, read those before we vote on the measure. Just teasing.
I'll explain the handouts in a second. All right, thank you, Madam Chair, for your time, and I will try to be brief here. Let me just explain the handouts. I think we've had a few requests for all the iterations of the bill. So I kind of did that last minute. If you have a turquoise sticker on it, that means that's the most recent one that Senator Strickland just spoke of. I just didn't have time today. We got it at 12:40 on email, and I couldn't make any color copies. So, but all the other bills with the pink tabs, those are the versions of the bills that have been placed. So let me first introduce myself. I'm Judge Young-I Sims. I work out of Gwinnett County Juvenile Court, and I want to put out first and foremost that the opinions and the thoughts that I expressed today are those of my own, given the experience I've had here in Gwinnett County, which is obviously a major metro county. We have the largest at-risk population in the state of Georgia, the largest school system. I think Judge Hurd is going to sign up to speak as well, and he's done an amazing job putting out the position of the Council of Juvenile Court Judges. And he'll hate me for saying this, but he's done it while maintained perfectly manicured hair, which is more than I can say for myself. I started watching the hearings on this, and I know one of the things that Senator Strickland had mentioned previously was he kind of wanted to give you a higher level view of this bill and a why of why the bill is being presented. And I thought here today I could kind of add on to that, but also kind of show you a lower level view, what I'm seeing on the front lines, and kind of the what in terms of what will actually happen if this bill gets passed. So first and foremost, I know one of the things he mentioned was this bill, the goal of it is to ensure due process and uniformity. And I don't think you're going to get many objections from juvenile court judges as to that goal. However, the way I read it, and I think y'all also got a handout from Judge Hurd last time we were here, that the juvenile court judges gave proposed alternative language. And in our proposed alternative language, it ensures due process, it ensures uniformity, and it does it in a way that does not limit a judge's ability to protect a child on a basis when we need it. And if you look again through all of the iterations of the bill, I mean, I want to say that I appreciate the changes that have been made. There have been significant changes, but there is still room for interpretation, and in my opinion, there is still, the bill itself is still vague in terms of what would be ordered by judges prior to a child being removed. One of the things I believe Representative Ballinger, Madam Chair, you'd mentioned was, consider on the record X, Y, and Z, all of the things that we have to consider prior to placing a child in defects custody. That is difficult for us to do sometimes because there are going to be many times where I'm in a delinquency disposition or a CHINS disposition. I'm not going to have any of that information. So if the law requires that I consider it before I can even place a child into defects custody, that is a problem. On the surface, I think we've said that we're trying to remove all of those things that makes it so a judge can't put a child in immediate protection. But unfortunately, what we have seen in this bill, or what I have seen, and my interpretation of it is that's not what we see. In terms of on the low level, what I am seeing in court, I can tell you from firsthand experience and from what I'm seeing in this bill is I believe DFACS is essentially saying right now that there are too many kids in foster care. As a result, they are having to hotel those kids, which is not anything that anyone wants, okay? I think DFACS would probably agree with me that our foster care system is overburdened and it is underfunded. And the solution for that needs to be something other than let's limit the amount of kids that can go into DFACS custody, right? The solution can't be to limit a judge's ability to immediately protect a child. The solution needs to be, let's give DFACS more resources so that they can recruit better foster homes, make more placements. The solution needs to be, let's give DBHDD more resources so that they can help us deal with this mental health crisis that our children are facing right now. The solution needs to be, let's give DJJ more resources so that they can create more community-oriented programs that can maybe help it so that a child doesn't have to come into foster care in the first place. Or what the First Lady is doing, pushing resources towards placements and places for human trafficking victims to go. These are the types of solutions that we need. Our solution can't be to backtrack and limit the amount of protection the court can give a child. When I make these decisions to put a child in foster care, it is not an easy decision, right? I'm making it because evidence has been presented to me in whatever form, whether it's at a disposition hearing, in any type of case. I have heard evidence that the home is so unsafe for the child that I believe a better alternative would be to place that child in foster care. And what that means is essentially ripping that child from his or her home. Maybe that child has a few minutes to put some clothes into a trash bag. That child is placed with a DFACS caseworker who is probably a brand new graduate, probably is gonna have to stay in a hotel off the side of the highway. But the evidence that has been presented to me to make that decision, I believe that at that point, with the evidence that I have, that is a better alternative than leaving the child at home. I'm trying to start a human trafficking court in my jurisdiction, so I've been going to a lot of these seminars, and some of the statistics they talk about are staggering. 60 to 75% of domestic human trafficking victims have a history in the foster care system. Okay. This is a statistic I know. So again, when I am making the decision to place a child into foster care, I am thinking in the back of my mind, there is a possibility, a very real possibility, that my decision can put the child on a path to being a human trafficking victim if they aren't already one. That is not an easy decision to make. I don't think there is a single judge in this state that would make that decision just because there's some loophole that says that we can make that decision. That's not what we're here to do. You know, if we're working towards the protection of the kids, then that's what we need to be doing. And I think one of the most poignant things that Commissioner Brose said in one of the hearings here is that foster care is hard, right? And I don't disagree with that. I don't think there's anyone in this room that would disagree with that. I see it on the faces of the kids who are begging me to send them home to their abusive parents. I see it on the faces of the parents who have no other option than to come to the court because there are no mental health places to treat their kids. They don't have the resources. I see it on the exhaustion of the attorneys and the caseworkers that come into my courtroom when I can get caseworkers. So, you know, if we're talking about having DFACS having a seat at the table, I can tell you right now from firsthand experience, in cases where dependency cases have been pending, they've gotten 3 months notice to be there, I cannot get a caseworker in the courtroom, even after I've ordered them to be there, because of the turnover in employment. And I don't take blame to anyone who you know, decides to come into this and get out of it. I mean, child welfare is hard. But we are in, I could tell you this, in Gwinnett County, at a county level at DFACS, we are in a crisis because I cannot get a caseworker to come in. And these are on cases where there are already parties, cases where they're already been given notice. So I'm not sure how this bill now wants to put DFACS at the table. I'll be the first judge to tell you, I'll shout from the rooftops. I want DFACS at every delinquency hearing. I want them at every dependency hearing. When we have CHIN's hearing, I want them there too. But I cannot get them there, even under the power of the court that I have now.
Okay, I'm
What I
sorry
think
to
we-
interrupt. We do have limited
Yes,
time.
ma'am.
Where the hour is late.
Yes, ma'am. I'll close
Everybody
off.
here wants to go home.
Absolutely.
So I would really strongly encourage the following, just to keep it to the bill.
Sure. And so
Um,
let me say this, is
you know.
that we've created the system that we're in now. It needs to be fixed. No one disagrees with that. But we can't fix it at the expense of the children that we are supposed to protect.
I will ask you one question,
Yes,
if I may. Can you point to me in the bill where this bill limits foster care placement?
So I think it can be interpreted, and again, I appreciate all the changes that have been made, but it says prior to placing a child into DFACS custody on a non-emergency basis, and I'll be completely honest, I don't know what that means because I've never placed a child in DFACS custody on a non-emergency basis. There have been cases where DFACS has worked and given services to families prior to the child coming into care, but I only place that child into care when
Okay,
those
let's,
exhausted are
I'm
resources.
sorry. If we can just keep
So
it to the
yes.
bill.
Comply with Article 3,
Mm-hmm.
consider on the record what services have been provided. If I don't know what services have been provided, can I go on with a hearing? I'm not sure. So, I mean, if we can clarify that, that's fine. And I think the language that the judges proposed does exactly that.
Okay, so considering is stalling your ability to.
Considering on the record, I think could be interpreted as stalling, yes.
Okay, all right, that's it? Okay,
I think DFACS shall have the opportunity to be present. I know they took out the words asking for a continuance. If they shall have an opportunity, I'm sorry.
Can you give line numbers, please?
Yes, ma'am. Line 32, DFACS shall have the opportunity to be present at a disposition hearing. I believe it's also repeated again in the delinquency portion. Lines 32 and 82 are the opportunity to be present. We shall notify DFACS by phone or email, lines 29 through 31, 38, 39, 79, 81, 87. And the consider is, I saw on lines, well, there are multiple lines of those, but I think those are easy to point out.
Okay, so inquiring and giving a notification to DFACS.
Yes.
Okay.
I think that could stall. And
Okay.
I think if we can clean up that language, that would be great. And
Okay.
it could solve the problem.
Okay, all right, thank you.
Thank you.
Does anybody have any other questions?
How would you clean up that language?
I
I
think
need
the-
specifics.
Yes, ma'am. The alternative that the juvenile court judges had provided, which means joining DFACS as a case, as a party in a CHIN's case, would do exactly that. Because being a party, they would have the right to notification, all of that type of thing.
Okay,
I believe that could clear it up.
okay, all right, number 27.
Thank you, Madam Chair, and maybe this is, the exchange that was just had is the easier way to address this, but Judge, first of all, thank you for the great work you do in Gwinnett Juvenile Court. I've observed it firsthand and the difficult job that you have every day. But is the concern that considering on the record is just ambiguous, and if there was some clarity as to what that consideration level needs to rise to, in other words, if notice was sent or if certain, there was the opportunity for the department to be present or to provide information, that may satisfy. It's just you're not sure what that means.
Right,
Okay.
and that would be my position, yes.
And then as far as the shall have the opportunity to be present, I guess it's the same kind of thing. It's just the question is what notice requirements required. As long as you know what needs to be done, then that
Absolutely.
concern could be addressed. All right.
Yes, sir.
Fair to say, though, that maybe there are some good protections here. Well, it's important that the department would have an opportunity.
Oh, absolutely.
So-
And I will say this, I put out there, I think one of the things we want to address is uniformity. In Gwinnett County, we don't ever do a bench removal without having the PPH 72 hours afterwards. So I imagine I'm probably not in the realm of the cases that Commissioner Brose was worried about. So there is a lack of uniformity when it comes across the state, and I think if we put those provisions in that the juvenile court judges had put forth, that could solve that problem.
Okay. All right. Anything else, Special Leader? Okay. Thank you very much. I
you.
appreciate it. And I do apologize to everybody, but I'm going to set a hard stop at 5:45, and we're going to call for a vote. So everybody, y'all can divide up the time as you wish, and also recognize that there are two folks that need to speak on behalf of the bill as well. So I'm going to give y'all half the time, so y'all have 4 minutes. Those that want to, Judge Hurd, Melissa Carter, y'all have 4 minutes between the two of you. I do apologize, but we have gone, okay, all right, sounds good.
Good
Judge Hurd.
afternoon, everyone. Thank you for having me back again. I will say that we have done a lot of work with the department over the past couple of weeks. We have come, and there have been some give and take on some things. There's one fundamental issue that still remains that we have been at an impasse to decide how to deal with, and that is whether or not in a Chin's case, we also have to make dependency findings, whether or not we also have to make a finding that a child is both Chin's and dependent. And that is a fundamental altering of the code as it was rewritten in 2013. This is not a new issue. It was debated ad nauseum prior to the passage of the code in 2013. It was determined and at that time that those cases would fall to defects, which is why the legislature removed the requirement that we also make a dependency finding in a Chin's case. You'll notice you'll find it in 6011. You find almost identical language with the dependency part removed in 442.8. And that is because the legislature intended to remove it. We do see that could possibly, we do believe it will cause problems with regard to being able to address the needs of these children if we have to make those findings. Because not all kids fit neatly into the dependency situation where a parent has done everything they know how to do but still is unable to control the child's behavior, can address the child's truancy, or what's the third one? Runaway, dealing with the child's runaway. The three predominant, to answer your question, Representative, the three predominant ways that children are Chins, there are about 6 or 7, but the three predominant ones are they're truant, they're runaway, or they're unruly and habitually disobedient. So that's the ones we primarily see. So we see that there's the way that it's currently written, and I do want to say that we have really worked hard with them, and this is the one issue that's still there. You guys get the opportunity to decide what the policy is, because that's what you do. We're just here to tell you that we think that it could cause problems on the ground if it's passed as is, and that's our position on that. So we just wanted you to be here to answer any questions.
Okay. All right. Representative Oliver.
I don't have your memo from last week in front of me.
Yes, ma'am.
So if you could be as specific as you can, what is exactly you want changed in the one area where you and defects are not in agreement? That's what's confusing me.
So currently, the title, Article 5 does not require that we also make dependency findings, that a child is dependent, as well as a child in need of services. We are required to make those findings in a delinquency case. That's why they're so fundamentally different in what we're dealing with. If we have to often make decisions on whether a parent is unfit, okay? But if a parent comes in and says, they've been in my office 15 times, and they said, I need help with my child, I can't get help with my child.
In relation to the Chin's case problem that is where you have a disagreement,
Yes,
tell
ma'am.
me exactly what language you want that is not in this.
Well, it's actually the language that we don't want in that is in, and that
Okay.
is the requirement that we comply with Article 3, which would require us to make a dependency finding in addition to the Chin's finding.
And your solution is just to take that out.
The solution is, yes, absolutely, with one exception, is that there need to be, and this is what we've been trying to iron out with them, there need to be some additional things in the Chin's statute from procedural standpoints. We need that part of Article 3 in. We just don't need the dependency findings. And they need that part in. And that's where we're stuck at.
Okay.
All right?
So it's basically compliance with Article 3.
That is correct. The
That's
dependency finding of Article 3.
The
rest of
dependency
it's fine.
finding of Article 3 that's already existing, that this bill doesn't change.
No, it does not. It does change. There is no requirement in Article 5 that we also make a dependency finding.
Okay.
Okay, that is the change.
Okay.
There's a requirement in Article 6 that we make it, and there's a requirement in Article 3, but there is no requirement in Article 5. And this bill would change it, and that's what it
Okay.
does.
All right. Thank you.
All right, thank y'all.
And the remainder of the time goes to Ms. Quick on behalf of the Division of Family and Children Services and Commissioner Brose. Table or podium, whichever y'all prefer. Okay. And again, y'all have like 3 minutes, and I do apologize, but we have to get the show on the road.
It's all right, Madam Chair, and thank you very much. And to the folks that I haven't met yet, I'm Regina Quick. Some I formerly served with in the House, and some I saw when I was General Counsel for the Lieutenant Governor. And I have the pleasure now of serving as Deputy Commissioner and General Counsel for the Department of Human Services. And let me just first say that there's a reason I continue to hand people copies of 151112, and that I asked Madam Chair to put it in your packets, because whereas Judge Hurd just told you there's an impasse on this issue was decided in 2013, and it was decided by the enactment of 151112, and I'm just going to ask you please to read along with it in terms of what it said about Article 3. There's a provision in the law for dual designation of these children. And 151112 explains very clearly that the time frames and requirements, this is in sub C, the time frames and requirements of Article 3 of this chapter shall apply to cases in which a child alleged or adjudicated to be a child in need of services or a delinquent child is placed in foster care and has also been alleged or adjudicated to be a dependent child. But the fact that these judges, as a council, oppose this matter tells you all you need to know about what is going on across this state. And the commissioner has told you of the instances in a previous hearing, and she's testified about the department getting a child ordered, removed from the bench into their custody that they didn't know its name for 48 hours. Because this is the way it's happening, not in an emergency situation. This bill doesn't address emergency situations. That is not what the bill does. That is not what the bill says. This is at a final disposition hearing, in a Chin's case where the department has not been a party, and a delinquency case where the department has not been a party and has not been at the table. They've not been there. They're not a party. Neither are the parents, by the way. Your constituents are not at the table in this. And so in a non-emergency situation, these judges are asking you to not make clear that 151112 and the law, the Constitution of Georgia and the Constitution of the United States requires some level of due process. And with that, I'm going to make sure I don't talk talk too much.
Okay. Very briefly.
I would also just point out, there are judges that don't have a problem complying with all of these protections in the law right now. And they can't come out here and vocally mention that because they have to make sure that they're careful that they don't upset some of their counterparts that don't comply. Okay, but those are also the same judges that a lot of them lean on for advice and mentorship. So I can tell you, this is not impossible. We are only asking that if a child is going to enter our custody, that it follows existing law, that their parents can come to a hearing and actually be represented by counsel so that their child wasn't taken away from them, sometimes over their objection. Sometimes a grandmother sobs in court whenever her grandson's taken away from her because it's determined by a judge that because he has autism, she's in danger. What would benefit that family would be services provided in the home. The law provides for that, but that is not always considered. We did not want CHINs to be a pipeline to foster care. We wanted services to be provided when it could instead of foster care. And this bill will move the needle on that.
Okay, thank you. I don't see any questions, so thank you for coming. And right now, we will take a vote. We are voting on SB 133, LC 480953S. All those in favor of SB 133? Oh, I'm sorry. I will open the floor for a motion. Move to pass by Representative Burchett. Several seconds.
Substitute motion.
Oh, substitute motion? Okay, I will hear your motion.
I remain confused on a couple of different measures, but since we're having a hearing tomorrow, I move that this bill be tabled so we can have a little bit more conversation and have a little bit more time to consider where the exact solution might come from.
Okay, I think we've heard this bill exhaustively. This is our second hearing, and I'm going to overrule that. So we have a motion to pass. We have several seconds. All those in favor of the passage of the bill signify by saying aye. All those opposed? Okay, hand vote. All those in favor of the passage of SB 133, please signify by raising your hand. Okay, all those against? Okay, 8-8, the chairman will vote for, and so motion carries. We are forwarding on SB 133, LC 480953S with a do pass recommendation. Thank you, ladies and gentlemen. We are adjourned.